I'm pleased to be joined today by Judge Michael Mukasey, who is the former U.S. Attorney General. Welcome, sir. Good morning, and good to have you here. You have been in the Attorney General's shoes, of course. What do you make of this political back and forth that's reported here?
Well, I'm not a political person, and my experience in those shoes was that decision gets made by the president and gets made on the basis of what best protects the United States, not based on narrow political considerations.
Yeah, I mean, it would appear from this story that Rahm Emanuel wanted to make it based on political considerations, and that it was not made on that. It was made more on what Eric Holder and perhaps the president both wanted to see carried out, and they believed that it was the right thing to do to bring this civilian trial to New York, right?
Well, in this case, I have to tell you, my vote is with Rahm Emanuel on principle grounds, not on politics.
Political, right. So talk to me. I also want to put, there was a letter, and this letter has caused a stir of controversy in Washington. It's a letter that Eric Holder wrote to Mitch McConnell. And in that letter, here is what he says about part of the reasoning that he had as Attorney General for why he believed that the trial should happen, why he believed, and now we're talking more about the Christmas bomber case, why he believed that he should be Mirandized, okay? And I want to get your thoughts on this as well. Eric Holder said in this letter, across many administrations, both before and after 9/11, the consistent, well-known, lawful, and publicly stated policy of the FBI has been to provide Miranda warnings prior to any custodial interrogation conducted in the United States. Is that your read on the law?
That's not my read on the law. The FBI follows its own protocols. Of course, they're used to apprehending criminals. But across prior administrations, and his own letter shows it because he's got some contradictory examples. This was to take people like Abdul Muttalib, who represented a possible intelligence source, and interrogate them. We did it with Padilla. That is the Justice Department, did it with Padilla. The Justice Department did it with Al-Mari. And that's cited in his own letter. In fact, his own Justice Department, in a case in New York right now, is taking the position that, as to a defendant named Galani, who has been brought over from Guantanamo to stand trial in the Cole bombing, that the fact that he was held at Guantanamo and interrogated was not a violation of his rights and should not be a reason for dismissing the charges.
I think when this was all initially announced, that these trials were going to take place in New York, people took it as, well, that's what's going to happen. An amazing groundswell has happened against this. Where do you think we go from here in terms of future interrogations? Are we going to treat these people as terrorists, or are we going to treat them as criminals?
I think the president has to make the decision, and I think the decision has to be made that if, as in fact is true, that he said that we are in a war, then we treat these people as unlawful enemy combatants. We get whatever intelligence we can from them, and then we figure out where it's best to try them. I happen to think that it's best to try them in military commissions. But regardless of that, the first consideration has to be getting intelligence so we know what these guys are going to do.
All right, Judge Michael Mukasey, it's a pleasure to have you here today, sir. Thank you very much for coming in.